All right, welcome back. You're still watching Daybreak on Trust TV. Now, there are strong indications that unless the Independent National Electoral Commission amends its regulation and guidelines for the conduct of elections, it might use the Electoral Act 2010 for the conduct of the 2023 general elections. This is as a result of President Muhammadu Buhari's delay in assenting to the Electoral Act Amendment Bill 2021, 23 days after it was transmitted to him by the National Assembly. Various civil organizations have continued to demand for immediate assent on the bill from the president as well. Now let's take a look at the implication of this delay, and we have joining us virtually INEC National Commissioner in charge of voter education and publicity, Festus Okoye. Good morning and thanks for joining us on Daybreak.
Yeah, good morning.
Now, it's been almost a month after, the Reworked Amended Electoral Act was forwarded to the president for assent, and he's yet to sign the bill. How much time does the INEC have?
Well, if you look at the matter constitutionally and legally, under Section 58 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, the president has been given 30 days within which to assent to a bill forwarded to him or refuse assent. And we understand that this particular rework bill was forwarded to the President of the Federal Republic of Nigeria on the 31st day of January this year. So the implication is that he is still within the constitutionally prescribed 30-day period within which to assent to the bill. The framers of our constitution are fully aware of the doctrine of separation of powers and also the doctrine of checks and balances. And that may account for the reason why they gave the president 30 days to look at whether to sign a particular bill or not. It's possible that they are looking at a situation where the president has to make sure that a bill forwarded to him does not have violate any of the provisions of the Constitution. It's possible that the president is also looking at the issues of cross-referencing and also the issue of the implementation of any law that has been passed by the National Assembly. So I believe that until the president exhausts his 30-day period, he's still within his constitutional right to either assent or not to assent to a particular bill.
What is the implication for INEC in case if the president doesn't assent to the bill?
Well, the implication is that the commission must rely on and operate within the confines and ambit of the existing electoral legal framework. As of today, the existing electoral legal framework is the Electoral Act 2010 as amended. The bill that is with the president, as far as the commission is concerned, is still incoherent. Is still not fully completed until the president gives his assent to the bill or refuses his assent, or until the National Assembly overrides the president's veto if the president refuses to give assent. Now, under Section 30 of the existing electoral legal framework, which is the existing law as of today, the commission has a total period of 90 days within which to give the notice for the conduct of the 2023 general election. And under our regulations and guidelines, we had already fixed February 18, 2023 as the date for the conduct of the election. So if the president does not sign the electoral bill within the period prescribed in the new bill for the giving of notice, we will simply rely on the existing electoral legal framework, which gives us 90 days to release to give notice of the conduct of the election.
2023, will the existing legal framework guarantee a fair and credible elections come 2023?
Definitely, it will guarantee the conduct of free, fair, transparent, and peaceful election. But the only thing is that if you look at the bill, the Independent National Electoral Commission was part of the making of this particular bill. From the beginning, we participated in all the public hearings that were organized by the National Assembly relating to this particular electoral bill. We also participated in the technical committee sessions relating to this particular bill. So we are fully aware, and we made far-reaching recommendations on how to improve the regime of the electoral legal framework. We believe sincerely that if this bill is assented to, it will add vigor, it will add color, it will add to the credibility of the electoral process or of the electoral regime, and also remove some impediments that the Commission had already identified as being a clog in the wheel of our electoral process. And I'll give you an example. For instance, under the new bill, the National Assembly has made it mandatory for funds relating to the conduct of the elections to be released to the Independent National Electoral Commission at least 12 months before an election. The implication is that the Commission can sort out its procurement processes and procedures on time, and also put its house in order and plan well. Secondly, the new bill has also made it mandatory that in making a determination relating to overvoting, that it is the number of accredited voters that will be used in making a determination relating to overvoting. Now, also in relation to the determination of pre-election matters, the new bill has pigeonholed the court that has jurisdiction in relation to pre-election matters to the Federal High Court, and now remove the state high courts and the High Court of the Federal Capital Territory. And for us, these are very, very clear, progressive, and creative innovations. It has also given us the leeway to transmit election results to the first level of collation and to other levels of collation, and using the transmitted results as a base for making a determination on when there's a problem with the manually transmitted results. So we can use electronically transmitted results for purposes of collating election results. So I think that there are progressive and creative innovations in the new electoral legal framework that will also add to the credibility and integrity and transparency of our electoral process.
Is actually taken, and the INEC is actually yet to release timetable and schedule of activities for the 2023 elections. Why the delay?
Well, we already have the schedule and timetable for the conduct of the 2023 elections. But as you know, as an electoral management body, we cannot close our eyes to the fact that there's a bill pending with the President of the Federal Republic of Nigeria, waiting for assent or waiting for him to decline assent. Now, the period for the conduct of elections, which the Commission has released, is based on our regulations and guidelines. But the main thrust, the main base, and the fundamental aspect of the law relating to the period for the conduct of elections in Nigeria revolves around Section 132, subsection 2, and 178, subsection 2 of the Constitution. Now, as you know, the Constitution is the fundamental law of the land and has pigeonholed the period for the conduct of elections. Now, based on the law, the Commission cannot conduct any election before the 30th day of December 2022, and we cannot conduct the election outside the 29th day of April 2023. But within this particular band, the Commission can recalibrate, readjust, and tweak the days for the conduct of election. So even if the President signs this particular bill by the first week of March, what the Commission can do is just to adjust the date for the conduct of election by just 1 week, and will still remain within the confines and ambit of the period prescribed by the Constitution for the conduct of elections. So if the Commission waits for at least an additional 2 weeks before releasing the timetable and schedule of activities for the conduct of the 2023 general elections, we are still within the time frame allowed us by the Constitution and the law.
Now, civil society organizations, and stakeholders have quite an eye, on this Electoral Act, and because everybody thinks it's going to be a game changer, for Nigeria's political space. Now, if eventually the president doesn't sign this, what message does this send?
Well, I will not be too judgmental in relation to the issue of the new electoral bill. This is because, as an electoral management body, the Constitution of the Federal Republic of Nigeria has given us the power and the mandate to organize, undertake, and supervise elections. It has also given us the mandate to register political parties, register voters, and conduct civic and voter education. This is our constitutional mandate. And as I pointed out, the Constitution is the fundamental law of the land. What the Electoral Act does is to prescribe the procedures and processes for carrying out what the Constitution has already prescribed. The Commission will still organize free, fair, transparent, and peaceful elections using the existing legal framework. But if the electoral bill is signed, it will also add to the transparency of the work we do. It will also add to the credibility of the work we do. It will also obviate some of the gaps and some of the loopholes that have been identified by the electoral management body, by the courts, by political parties, and by civil society groups and organizations. And so we will appreciate if the bill is signed, because it will also ease our work. But if the bill is not signed, we will still organize properly, and we will still conduct the best election that we can conduct, given the existing electoral legal framework.
Now let's get some more perspectives, from civil society groups. We have in the studio Ambassador Chibuzo Okereke here from a civil society group, Project Hope Alive Africa. And we also have Moshood Isa. He's a media officer from Yaga Africa to give us perspectives. Welcome to the program.
Thank you. Good morning.
Okay, let's start with you, Mr. Chibuzo. Yesterday there was a protest, that held at the Unity Fountain. Do you think in any way this is going to aid, the president to actually sign the Electoral Act?
Yeah, the protest was necessary. First, we are citizens of the country, and we have constitutional obligation as citizens to participate in democratic process, in our political process, and what have you. Unfortunately, in Nigeria, we always thought that only the political parties exist, and both the government and the opposition only listen to each other. Nobody gets to listen to the citizens. But democratic institutions are beyond the executive and the legislature. You have the judiciary, you have the citizens, you have the people of the fourth estate, of the realm, the journalists, you have civil society groups, you have non-governmental organizations. These are all democratic institutions. These people in the executive and the legislature are seeking for elections in this 2023. And they're entrusted by law to provide the kind of legal framework that will guide the same election for which they are interested party. So the hope of the citizens now relies on the civil society. And that was why we stood up yesterday as groups and citizens to demand that the president gives assent. And this is very important. I listened to my senior brother, Festus Okoye. I bet you that, he made a lot of insightful points, but I can tell you that if it was when he was in the other side, he was a civil society man, now in the INEC management institution, he would speak very differently. And listening to him, I think that President Buhari probably is taking advice from INEC. And that is not correct. The fact is that the current Electoral Act cannot lead us to anywhere. It can only lead us to more violent political process, fraud in our electoral process that will lack integrity. And we have seen that time and time again. How do you, in 2011, for instance, when we introduced the card reader, the president that introduced it, actually, that same card led the process to class suicide. Many people said he committed class suicide by introducing something that eventually affected him. But that is the kind of leadership that is required. If you go to court, we have seen court judgment that says these electronic devices are mere INEC regulations, that they don't exist in any law. Therefore, you cannot make a case using these things. Therefore, so you need to have them in our laws if we must go anywhere. And there are important provisions there. But let me say this. I don't think that Section 58 is necessary in this matter. The president does not need 30 days. You know why? This is not the first amended bill. This is the reworked bill. The president used 30 days to look at all the clauses in the first amended bill, 2021. And they pointed out in his letter to the National Assembly that he has concerns with clause 84 that dealt with issue of mandatory direct primaries. And many of us share the concern of the president that in a democracy, you cannot mandate that a particular mode of primary should be used, because democracy in itself is designed as a product of choice. There must be alternatives. Therefore, there is need to have direct, indirect, consensus, and what have you. And the president, even on national TV, said, if you can make this adjustment in clause 84, I will sign the bill. Okay. 23 days after that, you don't have to tell us that you need 30 days to look at the same clause 84.
Okay,
so
now let's
we
get
don't have that time.
Let's get Mashood Issa's perspective from Yaga Africa. Hello, Mashood.
Hi.
So Yaga Africa is one civil society organization that has advocated, for the president to actually sign the Electoral Act. Why the delay?
Oh, well, I wouldn't necessarily be asking Yaga Africa why the president is delaying assent to the electoral bill. But like my fellow comrade has said, there are a lot of important issues that were brought up in the electoral bill. And just to put a background on the fact that most of the provisions in this electoral bill are feedback from years of electoral observation of electoral process. We realize that in recent times, Nigeria's electoral process has been bedeviled by the same challenges we've been experiencing for more than 10 years now. So these are important feedback that were updated in the electoral amendment that requires speedy assent. Again, the president claimed they need to do a lot of due diligence on the Electoral Amendment Act before it can be passed. So this could be possible excuse or reason the presidency could bring behind delay in passage of Electoral Act. But like we said, this reworked bill was sent to the president on 31st of January 2022. This is like 23 days afterwards. And the president has no reason or no excuse anymore to sign this bill, because this bill contains a lot of important provisions that shouldn't be delayed. Talking about the electronic transmission of election results, the redefinition of overvoting, the fact that results will not be declared under duress, the fact that INEC will not have power to review results that were declared under duress. They are very, very important provisions that will enable citizens to participate in this electoral process. As we know, in the last general elections, we have barely 35% voter turnout because people are probably losing confidence in the process. But doing this continuous voters registration, we keep encouraging citizens to go out and vote. But this electoral act are more reason why you can encourage people to go out and vote, telling them that the process will now be better. Your vote will likely or will be more guaranteed to count. So this is more reason why the president should sign this bill without further delay. Of course, we know they have the law stipulate that they have the 30 days period to sign this act. But why delay till that time? Why delay till that time? The first time the bill was sent to him, he exhausted the entire 30 days before telling us the reason why he could not sign it. If he could check within the first 2 weeks and tell us this is why I could not sign it, this bill could be reworked even before the National Assembly went on recess. But then he exhausted the 30 days, the National Assembly went on recess, came back, the civil society organization continued to put more pressure on them until it was reworked immediately after he came back from recess. And then this is 23 days afterwards, we are awaiting assent. So I don't think there should be any major reason to delay this, considering the important provisions in this bill that would encourage citizens' participation.
Okay, now let me ask Ambassador Chibuzor. Now, in the event that the bill is not signed, where does that leave Nigerians in their quest for free and credible elections come 2023?
Well, clearly, if the president doesn't sign, many of us will encourage the National Assembly to override the veto power of the president, because that will be the only choice that we are going to have.
But can they do that?
Well, we have to push them to do it, because elections are coming. And see, That is why we must take away complacency from citizens' participation. Every citizen of Nigeria must activate its citizenship. Make no mistake about it, wherever you are as a citizen, the politics affect you. Everything is determined by the machinery of government. And the human element that controls the machinery of government in Nigerian system, it comes through the electoral process. So we should never, as citizens, make the mistake that it doesn't concern us because you're somewhere working and they pay you salary. This is what must happen. It happened in other countries. But let me say this. We should all be concerned. This is not about which government is in power. We are looking at a president who ran election 3 times, failed 3 times, went to court 3 times, and eventually emerged at the 4th time. This is, during those periods, this president cried out. He was the people's man. You know, he was a champion for electoral reform. And when he came on board, one would have expected that he would send executive bill on electoral reform. He didn't send the bill. During the National Assembly now brought the leadership bill that we are now using. And the INEC participated, but we didn't see any position paper from the presidency on the expectation they had. That is why many of us think that something is wrong, and they may not be interested in any electoral law that is new. Why? Is that this clause 84, if the president would have sent a memo during the process of the bill making, so that his consensus interest, indirect primary, everything he wanted could have been there. Because after all, the leadership of the National Assembly and that of the executive are all from the same ruling party, and they have the majority. So the implication for this, like Festus mentioned, is that there is procurement to be done, for Christ's sake. And some of this procurement, you are depending on third party to do it. And those third party have condition of service and timeline to deliver some of the things that you need. So if INEC, that he is saying that if the president just signed another, they need money on time. The new bill criminalizes appointment of political affiliates into the electoral management body. There are a lot of innovative things that are there. Any president, any political class that wants democracy to thrive in Nigeria, to flourish, to deliver happiness to the people, must ensure we have a credible electoral governing framework that people can believe in, and that can deliver the kind of election that we need. And remember that signing the law is not enough. Implementation is another thing. So the earlier we have the law, then we'll begin to strategize on even how to implement. So I don't think he needs 30 days. Forget about what the Constitution said. He's not breaking the law by signing earlier. It's a window of 30. Right? He signed the Petroleum Industry Act with fault. He noted that. He signed even 2022 budget with fault, and he even said it and signed. He even bought Tucano aircraft without appropriation, right? So there are many things he has done that demand urgency of time. This is one of those things that demands urgency of time, of national importance. And a president will leave a legacy of somebody who led the electoral reform that we have been fighting for 6 decades now.
We're really looking out to see, the president sign this subsequently. Now, before we wrap up, let me direct this to Yaga Africa. Now, during the FCT Council polls, there were some logistic, challenges that were noted, particularly with the beaver, bimodal machines and all of that. Now, do you think, with this problem being pointed out now, do you think it's going to be a problem for us in 2023?
Now, the fact that the Commission would now have legalized reason to use those electronic devices, it means the Commission have to also go back to drawing board, plan for this better. Not only the FCT election, we observed that in the Anambra governorship election. So, and now going into the 2023 general elections, Nigeria has a total of 170,000 polling units. It means INEC need to procure at least 170,000 beavers machine and at least maybe 10,000 backup. So now the ball will be in the court of INEC to make every provisions to plan better. And again, still go back to the electoral act. One of the provision of the act stipulates a particular period where funds must be released. In 2019 election, INEC claimed at some point that funds were not released until a few months to the election. If this bill is signed and the funds were released at the stipulated time, it means INEC will have better plan to deploy these materials, to secure these machines, get these materials ready, even do pilot testing ahead of the 2023 general election so that we would not have technological issues. These have been issues we've been experiencing over time, either it's logistics or technological challenges. But we have at least just less than 360 days to the 2023 general election, and then this is more reason why the bill should be signed, so that the funds will be released on time, and they could procure these materials, do their configuration, do a good pilot testing, so that we don't have these technological challenges ahead of 2023 elections.
Okay, now, while you have your final say, Ambassador, do you think this particular delay is deliberate?
Well, a personal opinion is that it's deliberate, right? There is no, we listen to the statement from the SA to the president and all that, and how he thinks that citizens and CSOs are ignorant of Section 58. I mean, that agitation, that statement is agitative, and that tells you there is something deliberate that is going on. And like I said, nobody has reason in this country as a citizen to trust that the political class will deliver the kind of electoral governance framework that we need. So nobody will intimidate us as citizens who have been there before. And we are here now. We must continue to demand that whoever the Constitution confers the responsibility to give us electoral framework that we need must do that responsibility. It is not whether he wants it or not. You are a servant as a leader, and your people demands that they need electoral law that can deliver credible election, that can elect legitimate leaders who will be responsible and responsive to the needs of the people. So, personally, it's deliberate. Even Mr. President knows it's deliberate. I say that because there are off-cycle elections in July in Osun and another one in Ekiti. I don't think anybody wants a new law that will change the political permutation, but we need that electoral law. They must commit class suicide for Nigerian democracy to thrive. Class suicide does not mean that is, they must deny themselves their personal interest in the process so that the general and public interest will thrive. When you say it, it's time to do it.
Well, we are really on the lookout, and we really hope the president eventually signs the bill. Thank you so much for coming on Daybreak this morning. We've been talking to Chibuzo Okereke from Project Hope Alive Africa, and also Mashood Issa from Yaga Africa. Thank you so much, gentlemen. We hope to have you next time on the program.
Thank you.